Okay, I think we'll get started if our presenters are ready. So I'd just like to start tonight by saying good evening. My name is Sue Larson, and I would like to welcome you to the webinar tonight. The personal injury sector is a complex one, and often medical experts say that they find it hard to distinguish between all the different schemes. So this evening, we're going to shine a light on two specific schemes: the Comcare Workers' Compensation Scheme, followed by the ACT Workers' Compensation Scheme. And to walk us through the key aspects, I'm very pleased to introduce our presenters, courtesy of our friends at Moray and Agnew. Firstly, Ben Mason. Ben is a partner at Moray and Agnew and the National Practice Group leader of the firm's Commonwealth Compensation and Merits Review Group, heading up the firm's Canberra government practice. He is an accredited specialist in government and administrative law with expertise in Commonwealth compensation. And as if that isn't enough, Ben has authored the ACT Legal Handbook chapter on ACT Government and Commonwealth Workers' Compensation, otherwise known as the Comcare scheme. We're also joined by Lauren Smith. Lauren is Special Counsel at Moray and Agnew for the ACT Workers' Compensation team. She has a background in statutory insurance lines, including ACT Workers' Compensation, and also regularly advises on common law damages claims, particularly in the areas of workers' compensation, public liability, and professional indemnity. Tonight, they'll be sharing their vast expertise to help us better understand the scheme, including compensable and non-compensable conditions, and we'll be using a case study to explain how to use these guides to calculate permanent impairment. As always, feel free, please, to put your questions in the question box, the Q&A box at the bottom of the screen. Our presenters will attempt to answer all the questions tonight, but if your question is not answered, given we've got quite limited time to cover off two very important schemes, a response will be sent to you after the webinar. So I'd like to now just hand over and introduce Ben Mason to you.
Thank you very much. Before I get into anything, I'll just quickly do the acknowledgement of country. Moray and Agnew acknowledges the traditional custodians of country throughout Australia and their connections to land, sea and community. We pay our respects to elders past, present and emerging, and extend that respect to all Aboriginal and Torres Strait Islanders peoples attending today. Now, I get very excited about talking about Comcare scheme and permanent impairment guides and assessments. I will speak quickly because there's a lot of content. The slides, I think, have just changed. There they are. And so we're going to cover essentially four areas. If you want me to repeat anything, or if you have any questions, I'm very happy to do that. And the other advantage of me going through quickly is that there'll be a bit of time at the end to talk about or answer any questions that might you might have. So essentially, to give you an overview of what the Comcare scheme is, and to describe where you're most likely to be involved in that process, which is providing reports or independent examination reports in relation to rehabilitation and liability and other compensation needs, and also the permanent impairment assessment framework, and some discussion about the current guide and the new guide that is about to commence. And then finally, I'll just take you to what that new guide may look like. It's not been published yet, but I do have a preview copy I can share with you and take you to that, just so you can visualize some of the things that I've spoken about. So the Comcare scheme, it's established by an Act, the Safety, Rehabilitation and Compensation Act of 1988. There are still a number of claims that are that relate to a period prior to the commencement of the SRC Act, I'll call it. And when you receive a letter of instruction and request for report, that should be made clear, because there can be differences, particularly in permanent impairment assessments. But by and large, you'll be dealing with conditions that arise after the commencement of the SRC Act. So we call it the Comcare scheme because Comcare, the entity, is the regulator essentially of the scheme. and it manages claims for the Commonwealth and most of its authorities. However, there are some licensees in the scheme. Some of them are Commonwealth licensees. The ACT government is also a licensee in the scheme, and it manages its claims in relation to its employees. So everything I say here, and not to confuse with ACT private sector that Lauren will be speaking about, but ACT government and Comcare scheme, they're one and the same. And there's about 40 licensees in the Comcare scheme. So licensees in the private sector, for example, John Holland is a construction company, and I think Linfox, so transport companies. So there's a number of, you'll see requests that says Comcare scheme that relates to a private employer. In fact, there are quite a few more people in the licensee side of the scheme than there are Commonwealth employees now. So although it's the government scheme, it is predominantly private sector or licensee. So just to give you some insight into the relevant players in the scheme, you have essentially the relevant authority, which is what the SRC Act talks about, which is essentially the insurer, the decision maker in relation to compensation claims. Then there is the rehabilitation authority. So we've got the relevant authority and the rehabilitation authority. The rehabilitation authority has the rehabilitation functions and powers under the Act. In most cases, they are not the same entity. For the licensees, they are the same entity, and that will become clearer when I talk about the different types of assessments that are done. Importantly to know is it's one of the last long tail schemes in Australia, which means that there is no cut-off. There are step downs in entitlements, but compensation is payable for life. So that is one sort of significant feature of the scheme. It also covers physical and mental injuries and ailments, and provides the full suite of compensation for both. So Moore and Agnew are on the panel for Comcare ACT government and a number of licensees, and so we do quite a lot of this work. Now, just very quickly, everything I talk about here, as I mentioned, Comcare and ACT Gov, there are some related schemes. So there's the C-Care scheme, which is almost identical to the Comcare scheme, and it uses the same impairment guideline. So if you do come across a C-Care scheme claim, it is essentially the same. There are a few differences, and again, the letter of instruction that you receive should make that clear. There's also the defence-related compensation claim scheme, which is for military personnel, and it is again largely the Comcare scheme with some embellishments. So if you ever get a defence-related claims or DIRCA claim, as opposed to an SRC Act or CIRCA claim, you know that they are essentially the same. There is a third scheme you will probably not come across, which is the Parliamentary Injury Compensation Scheme, which is based on the Comcare scheme. And so everything I tell you today is essentially going to cover all of those schemes. So accepted claims, very quickly, requires notice, a written claim, and a certificate from a legally qualified medical practitioner in order to have a claim validly made. Unlike most other schemes, there's no time frames for the determination of a claim, and there's no deemed acceptance or rejection provisions, which means that the process of having claims investigated and determined, on the one hand, it means that they can be properly investigated, but it also means that these claims tend to run for a lot longer than other state schemes. One obvious consequence of that you'll likely experience is that entrenchment of illness. As I often say, one of the worst things that can happen for a claimant is that they get better before they get to the first day of hearing. And this scheme is notorious. It will take, for a disputed claim, on average 1 to 2 years for the claim to be resolved. So bear that in mind as you go through examinations in this space. Disputed claims, just again very quickly, there's an internal review and then an external merits review process to the Administrative Appeals Tribunal. If you are giving expert evidence or you've given a report and you're called as an expert witness, you'll need to be familiar with the guidelines issued by the Administrative Appeals Tribunal. It's called the Persons Giving Expert and Opinion Evidence Guidelines. Again, that should be directed or linked in any letter of instruction you receive. Otherwise, you'll see it on the AAT website. And for those of you who haven't given evidence in the AAT or recently, they will quite happily accept evidence by video and occasionally by phone, and they quite like concurrent evidence to be given by experts with the same specialisation. And there's a very limited appeal to the federal court on a question of law only, and that is often pursued. The Comcare scheme has some of more jurisprudence and more high court decisions than any other scheme. Make up your own mind about what that means. Predominantly public servants to a no-cost dispute resolution scheme, but that's essentially what happens. So now I'm going to talk briefly about compensable injuries. When you are asked to provide an opinion, you're going to be asked to provide an opinion about whether there is a physical or mental injury in the ordinary sense arising out of or in the course of employment. And that's quite a common feature among the state schemes. There is another avenue for compensation to be payable when we talk about ailments that are significantly contributed to by employment. So that significant contribution is a test that's defined in the Act to be substantially more than material. So it's not predominant, it's not only, and it's not de minimis or merely material, it's significant contribution. The change from material contribution to significant contribution happened in 2007. So if you do have a pre-2007 injury, again, a letter of instruction should say, please apply a material contribution test, but otherwise it'll be a significant contribution test. The third avenue for compensation is deemed diseases. So there's a long list of occupational diseases, which some of you may be familiar with. For example, bursitis of the elbow is a specified disease, and work involving recurrent external pressure at or about the elbow for at least 6 months, whether consecutive or not, is the corresponding specified employment. So if that test is satisfied, there's a presumption that the condition is work-related, and then there's a reverse onus for the relevant authority, that is the insurer, the decision maker, to essentially disprove the claim. There are also cluster claim provisions which where there's a significant incidence of a particular disease in a particular location. For example, the breast cancer cases that occurred at APC's former Toolong Studios in Brisbane between 1995 and 2006. There's again an occupational relationship that's deemed with the onus on the insurer to disprove that there's a connection. So the last way that a condition can be compensable is if it is a result of medical treatment for an earlier compensable injury. And so this interestingly doesn't include aggravations, but it does include any new injury or ailment, but not an aggravation as a result of compensable medical treatment. So that is a very quick overview of the avenues for compensation, and your instructions should be quite clear as to which test you're being asked to apply. It's not always clear whether, for example, a mental injury should be treated as an injury or as an ailment. So in other words, is it something that arises out of in the course of employment, or do you apply the significant contribution test? The classic example is post-traumatic stress disorder. And usually it's the case if there's a manifestation of symptoms in the course of employment as a result of some, for example, life-threatening event, then it might be more readily characterized as a mental injury rather than an ailment. But by and large, mental conditions are assessed as ailments and require that significant contribution. So rehabilitation assessments. So there's two types of assessments that you're likely to be asked to do. One is for the employer, that is the Rehabilitation Authority, and the other is for liability and compensation purposes, which I'll talk about next. So there are two stages to a rehabilitation, pathways for rehabilitation. The assessment itself needs to be done in accordance with the Act. There's some requirements there about considerations that need to be taken into account when performing the assessment. Any employee can request an assessment, and the Rehabilitation Authority must arrange the assessment. You might, for example, be assessing someone who is 65 or 70 for their ability to perform work. You might be wondering why you're doing that when they've been retired for 20 or 30 years. It's because they've asked for an assessment to be performed and they have to provide the assessment. The second stage is a decision about whether a rehabilitation program under Section 37 should be provided, and that's discretionary. And in those circumstances, they'll receive the report and say, thank you. We don't believe, depending on if there is scope for either vocational or medical rehabilitation, then the Rehabilitation Authority may well say that the program's appropriate, but more likely than not, it'll be a decision that no program is appropriate. I've just included there a link to the guidelines for rehab authorities. The reason I've done that is because if you are asked to do a rehabilitation assessment for the employer, the guidelines also contain some useful information about understanding the different provisions. The report that's provided to the employer will also be shared with the the relevant authority. So, for example, Comcare, and that will be taken into account in determining the entitlement to compensation as well. You might find that you're asked to do a Section 36 rehabilitation assessment, and then you're followed up from Comcare saying, can you now please do a Section 57 assessment, asking in some cases similar questions, but more guided towards compensation than rehabilitation. Because this is a long tail scheme, rehabilitation is a very costly thing. As I mentioned, there's the automatic right for requesting rehabilitation assessments, and there's a positive duty on the employers to provide or find suitable employment. And the idea is this was originally an exclusively government scheme, and this all made sense. But now it's a very expensive proposition, providing, and there's an enduring requirement to provide or find suitable employment. So rehabilitation assessments, and you might find you do a report and then you're asked to do another report about 12 months later. Do they still have a capacity to do any work, and how's the rehabilitation going? You might wonder why you're regularly asked for your views about the prospects of rehabilitation. That is because in some cases the result of that further inquiry will be, well, there's no further rehabilitation that's appropriate, and in fact we can't find or provide any suitable employment, and then the employment relationship will end. So that is why that may be the case. Section 57 assessments, as I mentioned earlier, are assessments for liability and for compensation, and I'll sort of talk through what a permanent impairment assessment looks like. One point to note about the Section 57 assessments is you may be asked to provide an assessment when no claim for compensation has been made. The power to request an assessment under Section 57 arises when someone has given notice of injury. It doesn't happen often, but if someone has given notice of a significant injury but hasn't put a claim in, then you may be asked to do an assessment at that point, and the questions may be more limited. So essentially the way claims are determined in this scheme is rather than being proactive, that is the relevant authority saying, here's all the things you may be entitled to. A claim is made for each head of compensation. That might be medical treatment, it might be aids and appliances, it may be for incapacity payments, which is the economic loss compensation, or permanent impairment compensation, and generally a request for an opinion will relate to one, sometimes multiple heads of compensation. More often than not, it'll be around a single head of compensation, so incapacity payments, and there'll be a suite of questions about performance of work, the ability to perform the pre-injury employment, and other relevant factors. In relation to permanent impairment, there's the entitlement arises under the SRC Act, where someone has 10% whole person impairment, and the assessment therefore is looking to see whether they have at least 10% whole person impairment. There are some exceptions. Hearing loss, for example, the whole person impairment threshold is 2.5%, and loss or effective loss of fingers, toes, sense of smell or sense of taste are 1% is the threshold. And I've just given you the section references if you are inclined to look them up. When we instruct our experts for a permanent impairment assessment, we will outline what we're asking for. But very briefly, impairment means the loss of use or the damage or malfunction of any part of the body or any bodily system or function, or any part of such system or function. Non-economic loss in relation to an employee who suffered an injury resulting in permanent impairment means loss or damage of a non-economic kind suffered by the employee, including pain and suffering, a loss of expectation of life, or a loss of the amenities or enjoyment of life as a result of that injury or impairment, and of which the employee is aware. When you do these assessments, my strongest recommendation and best advice to you is to, with your letter of instruction, see specifically what they're asking you to do. Most of the time, the questions will be intentional. They may not include all the questions you might expect to be asked, and there may be reasons for that. But otherwise, if you're being asked to do a permanent impairment assessment, the starting point is the approved guide called the Guide to the Assessment of the Degree of Permanent Impairment. And if you've used this guide before, you'll see many similarities with the AMA 5. It's essentially a modified AMA 5. Some of the criteria come from AMA 2 and AMA 4, but by and large, it's a modified AMA 5 guide. That guide, and I'm just going to go to the next slide. That guide is broken up into essentially three important introductory elements. There's an introduction which sets out everything you need to know about doing the assessment. The principles of assessment are more detailed instructions in relation to various things. So, for example, an elaboration of what impairment means and non-economic loss, and discussion of what to do if there's a pre-existing injury, etc. And I'll talk about that briefly in a moment. But my strongest advice is to start from the top, read the introduction, read the principles of assessment, and read the glossary before you do anything else. So you have a really good sense, and you've centered yourself in the world of these Comcare permanent impairment assessments. There will be similarities, but there will be differences. So it's best not to assume that it is simply an AMA 5 assessment. And the guide is freely available either on Comcare's website or from the legislation.gov.au. The guide itself is divided into 3 divisions, which, as I've set out there on the slide, the permanent impairment division, which has chapters, sections, and tables. Some of them are directly taken from the other guide, but most of them are modified. The reason that they're modified in many instances is because of this 10% threshold. They need to be able to have an assessment that is at the 10% threshold. So where you look at the AMA 5, it might go from 8 to 13. They need to have a 10%, so they're going to try and find some halfway point. You need to satisfy all of the criteria in any particular table. You can't pick between the assessment ranges, and that's made very clear in the principles of assessment. But when you have read the introduction, principles and glossary, you identify whether you're talking about, for example, a psychiatric condition or a physical condition. If it's an orthopedic condition, you would go to the relevant chapter, and there'll be an introduction to each chapter. You need to read the introduction to each chapter because it specifies or gives instructions precisely as how to perform the assessment. So it is much clearer once you read all of those things and follow those things, and they won't necessarily be in the letter of instruction to you. Division 2 talks about non-economic loss and how to assess that. Generally speaking, you're probably not going to be asked to assess non-economic loss. If you are, it's essentially a best guess because it's a very subjective thing. So you may have to ask questions about, the effect on social relationships, and then you have to choose somewhere between 0 and 5 in terms of the effect, and all of that gets added up. Division 3 is the calculation of entitlement. You're unlikely to be asked to do that. You may be, but you're unlikely to be asked to do that because essentially that is the job of the relevant authority who's making a decision about any claim, to take all this information and work out what the entitlement is. You might be asked to do it, and it would simply be a matter of going through the pro forma and adding numbers in. What is really important to note is that some impairments can be combined and some can't be combined, and some are added. And the instructions as to whether you add, combine, or don't combine are in each relevant introduction to each chapter. And so in the new guide, which I'll give you a preview of in a moment, they are highlighted, those instructions, so you should know whether to combine or not to combine. So that's the elements. I want to simply sort of talk about a few of the, I've got too much longer, but a few of the new elements in the approved guide. So the current edition is edition 2.1. Edition 3.0 will be published or come into effect on the 1st of April this year. There are some new, as I say, elements to it, or there may be new elements to it. I haven't seen the final version. The survival of claims component is new, and essentially that asks for an assessment in circumstances where someone has passed away, not of what their level of permanent impairment was as at the date of death, but what their level of permanent impairment would be had they received full treatment and full rehabilitation. So what would have been the course of, or the trajectory, likely trajectory of that. There's also a new section about pre-existing conditions, where it delves into quite a lot of detail about how to manage or how to assess pre-existing conditions. Generally speaking, it'll be a matter of not simply saying, I assess today your whole person impairment as being 20%, but because I think you have 40% degenerate, 40% of your condition is a result of some degenerative process. It's not a matter of applying a 40% discount to the 20% whole person impairment. You'll effectively have to do two assessments. What was the impairment, as best you can tell, based on clinical records, or if the history is the only thing you have from the claimant, what was their level of permanent impairment prior to the injury, and what is the level of permanent impairment now, and then the assessment will be made on that basis. That is going to happen in most cases where there is a pre-existing condition. If they have a pre-existing compensable injury, you can ignore that first injury and assess the second injury as if the first injury didn't exist, because this scheme provides compensation for each permanent impairment from each injury. In the remaining time, I'm just going to take you to the guide. Bear with me. So hopefully you can see the this is the exposure draft of the 3rd edition guide, and I'll just flick through. This is just the I'm just going to go back up again, sorry. The introduction goes through the application of the guide. You won't need to worry about that. You'll be essentially, any claim received after the commencement of this guide will be assessed under this guide, and you'll be told which guide to apply. The only other guides you may be asked to apply generally will be edition 2.1. They are substantially the same. There's a different chronic pain assessment criteria, but essentially they are the same. So I've just gone through the index, and so this is what it will look like. This is the introduction to the guide. It's now all hyperlinked, so it should be much easier to navigate, and the instructions they've been sort of revised and made to be as clear as possible. So they're the introduction points, so there's not a lot of reading. The principles of assessment, again, you need to go through these. If you've got a situation where there's a pre-existing condition and an aggravation, follow these instructions. If you've got a pre-existing condition and injury other than an aggravation to the same body part, system or function, you would apply these instructions. So that's the principles of assessment. Actually, I'm going to go back up. Exceptions to the use of this guide. There are circumstances where you will need to go to AMA 5 because the Comcare guide does not have an assessment criteria. Importantly though, chronic pain conditions are not assessed under AMA 5. You must assess them under the Comcare guide. If it's a rare condition, you simply cannot find a home for it, and you can't find a home for it under AMA 5, then you would use clinical judgment to determine the most likely level of whole person impairment. If ever you're asked to do that in the guide, and there are circumstances where you are, make sure you provide detailed reasons for why you've arrived at your opinion. So this is an example. This is the last part of my presentation, but so we're looking at Division 1, Chapter 1, the cardiovascular system. There is introductory comments which will tell you how to do the assessment under the relevant tables. In a number of chapters, the activities of daily living are set out. They are essentially the same throughout, and when you provide your assessment, you may be asked to directly look at the activities of daily living. Otherwise, it's implied, it's inferred that when you're doing these assessments, and if you take into account the effect of the injury, if you are deciding between, say, 2 assessment ratings, and then we have the tables. So I'm going to pause there. Do I have any questions, Sue?
Yes, we've got a few questions. The first one is relating to these guides. Does a pre-existing condition apply to inguinal hernias due to genetic differences in collagen?
So, so can we take that again? So, do the pre-existing? Sure. Yep.
Condition.
Yep.
Does a pre-existing condition apply to inguinal hernias due to genetic differences in collagen?
Well, so that's going to be a matter of again addressing whether the condition is one that is it's highly unlikely to be a compensable condition, the genetic condition. It's possible, but assuming that you don't have a pre-existing compensable condition, you would need to go to the relevant table and conduct an assessment under the table as of now. If you are able to assess the level of impairment prior to the injury, you would do so. If you can't, the guide says you take the current level of permanent impairment as being the assessment rating for the particular claim condition. And that's obviously a generic response, but that will apply to any situation where there's a pre-existing condition. If you want more specificity on that particular question, because it is technical, I'd be happy to take that offline and answer that.
Great, thank you. Okay, just as we're switching over to Lauren, just another question around, just a clarification around that, around people with collagen problems. Dr. Sharp, I can't turn your microphone on. Let's discuss offline. Yep, that's great. We'll follow up offline. There was another question though, and it was around disputes right at the start of the presentation, Ben. And it was just a question around, is there any specific reason why these disputes seem to take so long to resolve?
Yes. Well, part of it is that time frame issue. There's no provisions within the Act to require that decisions be made. It does say they need to be made quickly, but there's no actual time frame for decisions to be made. So normally, as I say, if it's a disputed claim, it'll take about 6 to 12 months before it gets to the tribunal, and the tribunal will then, which is an independent body of the decision maker, we will try to get a matter resolved in under 12 months. I think they track at slightly over 12 months, but obviously if they are very complicated, then they can take longer, and it's also not uncommon for people to have multiple claims made sequentially, and the tribunal say, well, we won't have a hearing until they've all caught up in the tribunal. So there's a few reasons why that is the case. I know there's a lot of work being done to try and get early dispute resolution in, and the extent to which medical opinions are useful. Quick medical opinions early on can have a significant effect for the outcome, both for the claimant, but also the compensation payer. Yeah.
Okay, thank you for that, Ben. Okay, we're now going to move across to Lauren. Thanks so much, Ben. We may have some other questions that come across, but at the end we'll wrap a few up, and we'll also send some after the presentation that may present. So I'm just going to hand over now to Lauren.
Sue. Thanks everyone. So as Sue mentioned at the beginning of the presentation, my part of the presentation is on the Workers' Compensation Act 1951 in the ACT, which relates to private workers, with the exception of those licensees which Ben mentioned, which have elected to go into the Comcare scheme. I'm actually going to focus on one part of the ACT scheme, which is the calculation of permanent injury compensation, because that seems to be a bit of a mystery for doctors and some lawyers alike, and also claims officers, to be honest. And the key part of it actually is the assessment of the loss, which is why it's important for doctors to understand how that's done, as that gives the claims managers and the lawyers, or whoever's calculating the compensation, the right tool, I guess, to actually calculate it correctly. So I'm going to provide a little bit of background about the relevant parts of the Act that relate to that permanent injury compensation. And I'm also going to tell you how to actually calculate it, because that might be of interest to you, just so that you know what it is that we're trying to achieve at the end. So hopefully this is helpful and informative, but if you've got questions as you go along, let me know. Otherwise, I will kick off. Now, Sue, do I have the access to the slides?
Yes, you do. So you've got the remote control. Are you able to see the screen, Lauren?
I can, but I don't have the tool to actually...
Just down below, there's the arrow.
Oh, sorry. Hang on. Have I clicked across now?
There you go. Just down the bottom of the screen. Just here is the arrow, and you can press that.
Yeah, I don't have that on my screen.
Okay. I'll be your arrow pusher.
Okay. So let me just make sure that I'm starting on the right slide. Sorry, go back. Yeah. Okay, so slide 2. Oh, sorry. This, yeah, so compensation for permanent injuries falls under 4.4 of the Workers' Compact. If you feel like a read, there are some provisions I'll talk through during the presentation. Sometimes it can be helpful to actually have a look at them when you're doing your assessment. You can, of course, find a copy of the Act online. So part 4.4 is the relevant section. And basically that provides that a lump sum can be awarded to a worker as compensation for a permanent injury. That's separate to their weekly benefits, their wages if they're incapacitated for work, and separate to their medical expenses. They can't claim permanent injury earlier than 2 years unless the court allows it. So you have to make an application to the court, or unless it's unlikely that there'll be any improvement or further improvement in the use or efficient use of the injured part of the body. The obvious reason for that is that you can't assess properly what the permanent impairment will be until such time as the injury has stabilised. So where the injury does not affect 100% of the body part, for example, loss of a limb would be 100% loss, I would say. A percentage of the loss is then calculated. So the important concept to note here is that we're looking at the body part that's injured. There might be multiple body parts, but in the ACT scheme, whole person impairment is a foreign concept, and any assessments on WPI actually aren't useful in this scheme at all, unlike the scheme that Ben was talking about, the SRC scheme, and other jurisdictions like New South Wales. WPI is something that you would probably interact regularly if you're doing these types of assessments, but in the ACT, WPI is not something we can use, and I'll go through that as part of this presentation. So the next slide. So this Section 51 in the Act says that if a worker has suffered a loss mentioned in an item of Schedule 1, and I'll show you Schedule 1 in a moment, they're entitled to receive the percentage of the single loss amount mentioned in that item. And Section 53 says if there's more than one injury, the combined amount is not to exceed the maximum loss amount. So the concepts of single loss amount and maximum loss amount are for the purposes of calculation. So you as the assessor don't need to worry about those two terms, but the relevant part to point out is the loss mentioned in an item of Schedule 1, which I'll come to in a second. So through the next slide, please. So I guess we need to look at what is a loss. So it's defined in the Act. It means the loss of a thing or the permanent loss of the use or efficient use of the thing, and includes permanent musculoskeletal impairment or another permanent impairment, a loss, damage, impairment, disfigurement or disease mentioned in Schedule 1. So we refer to Schedule 1 again. There is no permanent impairment permanent injury compensation, for a psychological injury or disability in the ACT scheme. So that's just something to note. It's only dealing with physical injuries and impairments. So if you go to the next slide, this is Schedule 1. So this is at the end of the Act. I've just put page 1 here, but you can see there are 3 columns, and this I think sometimes can be a little bit confusing. Column 1 simply is just the number of the items. So there are a total of 53 items for which permanent injury compensation can be awarded. Column 2 is the relevant column for you as the assessor. So you can see some examples there. You've got loss of power of speech, you've got hearing loss, you've got loss of vision, arm injuries, there's leg injuries, back injuries, brain injuries, and there's also things like scarring and cosmetic injuries. And then column 3 is that single loss amount, which I referred to earlier when I was talking about single loss amount and maximum loss. You don't need to worry about that column. So I will show you how that applies at the end of the presentation so you can see, but you don't need to, you can pretty much ignore column 3 and column 1 and just focus on column 2 when you're performing your assessments. The next slide, please, Sue. So calculating the loss, how do you do it? And this is the important part, I think. So I'll just reiterate again, whole person impairment not used in the ACT scheme. And the assessment relates to how an injury affects the specific body part as opposed to the whole body. And you attribute a percentage of loss to that body part. The percentage of loss is calculated with reference to AMA 5, as well as the New South Wales Work Cover Guides for the evaluation of permanent impairment, the 3rd edition. Now, I'm aware that there is a new edition out, which is the 4th edition. I haven't had an opportunity to review the changes in detail, but I do know that those changes are with reference to the PIC and CIRA in New South Wales. Those schemes are very different to the ACT scheme on many different levels. So digging around, what I've been able to find is that there is an instrument by the minister at the time in 2010 who said that we need to look at AMA 5 and the 3rd edition of the Work Cover Guides. So I've managed to dig up the 3rd edition and I've emailed it to Sue. If you're having difficulty finding it, because we did initially, then Sue can help you point you in the right direction. But in other words, so just the AMI 5 3rd edition, and as with the Comcare guides, I'm not sure, Ben did say what they were called, but the Work Cover Guides are also modelled on AMA 5. So they've been tweaked to suit the New South Wales system. And for that reason, because the schemes in ACT and New South Wales are so different, I would suggest looking at AMA 5 at first instance, and if there's something in there that doesn't fit the assessment you're doing, perhaps then look to the Work Cover Guides to see if they address the issue. The next slide, please, Sue. Okay, so this is how you approach an assessment. So many of you who've done assessments for workers' compensation generally, you've probably are just asked to assess, what does the worker report as their injuries and disabilities. You perform an examination, you come up with a diagnosis. You also have regard to the medical material from the treaters. You might get a request to do that, but as well as do a permanent injury assessment, or you might just get an assessment for the permanent injury assessment. Either way, when you're doing this permanent injury assessment, the things you need to look at, first and foremost, has the worker's injury or condition resulted in an impairment? i.e., is there something still going on with that injury, or has it completely resolved? If it's completely resolved, then there's no permanent impairment and therefore compensation won't be payable. Assuming there is an impairment, has the worker reached maximum medical improvement? So this is obviously when the worker's injury has stabilised. It's unlikely to change substantially in the next year with or without medical treatment. If at the time of the assessment the worker hasn't reached maximum medical improvement, then the assessment should be deferred. Because obviously if there could be changes, then the assessment might be more or less once the injury has stabilised. So it would need to be deferred. And I suggest if you have someone that sent you, it might be worthwhile actually giving the person who instructed you a call just to discuss it before terminating the assessment, in case there's some reason, or obviously if you're providing a general assessment separate to that, you do the normal assessment and you just have to defer the permanent impairment assessment. So those two things have been satisfied. Obviously the next and the most important thing is, what's the degree of permanent impairment resulting from the injury? So this is what we ask the doctors to assess for us under the AMA 5 or the Work Cover Guides. And I'll come to that in a second. Just when you're doing the assessment, under section 61 of the Act, it talks about the proportion of permanent impairment due to previous injuries or pre-existing conditions, and says that you must deduct that. So I think in Ben's circumstance, if I understood him correctly, in the Comcare space, you ignore them. In the ACT scheme, you actually have to figure out what percentage is that previous injury or condition and deduct it once you perform your assessment as you normally would, figure out what the impairment of the arm, say, is, and then you have to figure out, well, what proportion of that is actually pre-existing and do a deduction. If you go to the next slide, Sue. Now, sometimes it's not possible to actually identify with accuracy what that prior, or what attribution the pre-existing condition or injury might have. The Act says that if it's too costly, and by that I assume that means, undertaking a suite of tests and those sorts of things, or if it's just too difficult to work out what the deductible portion, which is the pre-existing injury or condition, is, then there is a presumption that you just apply a reduction of 10%. Having a look into this further, there doesn't seem to be any case law or other guidance that I can find anyway as to how you're to assess this, and realistically it's a matter for you using your skills and expertise and your experience in the matter to see whether or not you can come up with some reasoned sort of percentage of what the prior injury or condition is. There might be some instances where it's obvious, that pre-existing condition or injury is a significant part, and therefore 10% is not sufficient. And in that case, you might venture a guess at what that pre-existing attribution is. But if not, it's just 10%. And what that means, so for example, if you work out that the permanent impairment of, say, the right arm is 30%, you deduct 10%, so 10% of 30% is 3%, so the resultant loss is 27%. That one I haven't actually seen come up a lot, to be honest. And like I say, it's a bit of a grey area in the sense of having no guidance, but if all else fails, 10% is the deduction you apply. Next slide, please, Sue. So the AMA guides, I just want to preface that I'm not an expert in these guides. I have a copy sitting next to me. I've had a look at it. I'm not trained in its use. I assume that most or all of you would be, or at least they make more sense to you as doctors than they do to me. But just going through the basics, you'll see that, in the guides, each body part or organ is contained in a different chapter. For example, lower extremities are assessed in chapter 13. And there are different methods within each chapter as to how the assessments are done. So the basis for examination can vary and between anatomic, cosmetic and functional and diagnosis. And physical examinations, a review of pertinent records and imaging and ancillary testing are all essential. So I know that we've sort of been through this whirlwind of COVID, which has introduced, AVL assessments. And a lot of the time, the assessor, if they're not in the same area as the worker, there'll be an allied health professional who you can direct to do your assessment. That's probably appropriate, but I would say that if there's no allied health professional in that setting assisting, that it's probably not going to provide a very good result in terms of accurately assessing what a permanent impairment is, because I think the examination is actually quite key. So just something to consider if you're asked to do a PI assessment. The other thing I noticed when I was looking at the AMA guides this afternoon is coming back to this no WPI in the ACT scheme. I was looking at chapter 17, I think it was, and I'm not sure if it's in all of the chapters, but it actually tells you how to translate say, a WPI down to a whole body part, such as a limb, down to a specific body part, such as the foot. So WPI, all of the figures in the book that I could see didn't have parentheses around them. If they were referring to a whole body part, such as a limb, they had parentheses, which is the round brackets. And if they had a specific, it was referring to a specific body part, it had the square brackets around it. So that's a helpful thing to look at. So if you're looking at figures without parentheses around them, you're looking at WPI and you should avoid that. Or alternatively, you should do the calculation to bring it back down to the whole body part or specific body part, depending on what you're assessing, and I'll get to that shortly. And it also does tell you in the chapter that I read anyway, it tells you how to do that calculation if it doesn't have a ready reckoner as to what the calculation will be going up or down. Next slide, please, Sue. So I guess the reporting, when you're providing a report on permanent injury compensation, and it's really important to provide clear reporting. There's a couple of reasons for that. One is because you might be asked on behalf of a worker to provide an assessment, and there might also be another doctor, might be asked to do an assessment on behalf of an insurer. The two doctors might come up with different answers, and that's okay. There's no one right answer. Like anything, there's no one right answer. You will have different opinions based on your own expertise and skills. Where that happens though, the importance of the reasoning behind it and setting it out in your actual report can be useful, because it can actually allow the parties to try and figure out where the differences are, and either then go and have that issue dealt with by the doctors again, or query the doctor about that a bit further. Or it actually gives the court, if we end up having an arbitration and can't resolve the issue between the parties, the court actually will arbitrate on what the permanent impairment loss is, and that will give some guidance to the court. So I'm going to show you in the next few slides the things that you should, I guess, tick off when you're providing your report. I think from looking through the AMA as well, it actually also gives lots of examples, which is really helpful, and it sort of mimics almost what I'm going to show you on the next few slides. So if you could go to the next slide. So here, and most of the reports that I see have all of this usual information. You usually get a background given to you by the person instructing you. But then you'll take a history yourself from the worker. So here we've just got an example of a worker, 35 years of age, twisted their ankle, has had surgery to treat the fracture, and is undertaking some conservative treatment post-surgery, has some ongoing but modest symptoms. Next, Sue. So the diagnosis, you provide a diagnosis like you would with any assessment: fracture of the right ankle. You're satisfied that it's been caused by, or in the course of the employment. It's 2 years post-injury, so we've ticked that box. There's some treatment, which is just an ongoing at-home exercise program, and prognosis is guarded for further recovery despite treatment. So that prognosis indicates to me that there's an impairment, and therefore there's an assessment that you can conduct, which will allow them to submit an entitlement for some compensation for that impairment. Next slide. Which it says condition has stabilised. There you go, and worker has reached maximum medical improvement. So in this example, chapter 17 refers to lower extremities. You've got the results of the examination there. Now I'm not really sure, these are just made up figures, so please don't hold me to the assessment being correct when we get to the next slide. But you can see there the factors that have gone through in the examination with reference to what the guides have told you to assess. And the methods used are down the bottom: gait derangement, range of movement, ankylosis, diagnosis-based estimates. Next slide. So here's the assessment of the permanent impairment. So again, like I said, I'm not sure if these are actually accurate with reference to that examination, but we've got a right lower limb impairment of 7%. So that's the whole of the right lower limb, with reference to the tables at 1711 and 1712 in the AMA. And that then translates, when you've done the calculation, to permanent impairment of the right leg, but just below the knee. So you're reducing the area where the impairment is, because it's the ankle. And we have a result of 12% is the answer in this particular scenario. Also in this scenario, I haven't made things too complicated. There was no previous injury or underlying condition to assess or consider. So if you go to the next slide, just some other things, and this is where you might want to venture a look at the Act if it's relevant. There are some specific provisions in Part 4.4 about particular losses. So I've already touched on the first one, which is further payment can be made if there's an increase in the loss of the efficient use of the injured part of the body. That refers back to the assessment if there's a previous condition or pre-existing condition or injury. So it might still be the same work condition, but in terms of you performing the assessment, you'd need to then figure out what did the earlier assessment say and what is now the increased portion, so that the compensation can be worked out accordingly. Section 54, if a worker is left-handed, you actually treat that as the same as if the right-handed. And if you have a look at the Schedule 1, you'll see that it's got loss of the hand. So left hand, right hand, it doesn't matter if they're left hand, you treat it the same as the right hand. Sue seems to have dropped out, so I'm not sure if you can all still see the slides. Let me just pull my slides up. I'll just keep talking if that's okay. Interrupt me or send me a chat if you've all been booted off or can't see anything.
Lauren, Sue's just coming back online now, so if you just keep talking through your slides, she'll be with you very shortly.
No problem. So sorry, I was talking about left hand, right.
I'm back.
There we go.
Back. Would you like me to progress the screen?
No, that's okay. I'm still on the same one.
And can you see the screen still?
I can.
Great. Sorry, just a big thunderclap there.
Oh, no problems. So section 56 of the Act, this is specific, we're still on specific provisions relating to particular losses. Loss of an only arm, leg, hand or foot is treated as the loss of both arms, legs, hands or feet, which makes sense. Section 57, there are specific percentages for the loss of sexual organs, with the maximum single loss amount of 47%. Next slide, please, Sue. Actually, I think I can control it now. I can. Section 58 relating to bowel function. So the bowel is taken to include the anal sphincter. Permanent ileostomy and permanent colostomy are each taken to constitute permanent loss of bowel function, for which the maximum percentage is payable. So that's the situation. I gave an example earlier on about there being 100% loss and suggested that might be a loss of a limb. This is another example of 100% loss with reference to a specific provision in the Act. And section 59, subsection 2 says that you can't consider how an aid will reduce the loss. So if someone has lost part of a limb, for example, you can't use the prosthesis and have them use that and do the assessment. You've got to assess them without the prosthesis. Section 64, there's specific requirements for hearing loss. The threshold in the ACT scheme is 6%. So the worker has to have more than 6% hearing loss in order to be entitled to compensation. It's worked out as the proportionate loss of hearing in both ears. even though it might actually be higher in one than the other. And there's also an age deduction to be applied, which is 55 years for a male and 65 for a female. Now that's a pretty old approach to things, and I suspect comes from days long gone where males were sort of more likely to work in heavy industry than females. That's changed, I think, but that's what the Act still says, so that's the way we deal with it at present. So calculating the loss, just a couple of other things. This is more relevant to the person actually performing the calculation, but I'll just quickly run through it. I think I've only got a couple of slides left, and then I'm going to show you an example. So section 55 says, if a loss other than the impairment of the back, neck or pelvis may be compensated by a combination of items in Schedule 1 or by a proportionate loss of a single item, the loss is to be compensated by a proportionate loss of the single item. So a couple of examples there are, if there's 2 or more fingers, you compensate it as a loss of the proportion of the hand. Loss of an arm at or above the elbow includes the loss of the arm below the elbow, and the loss of the hand is to be compensated as a loss or proportionate loss of the arm at or above the elbow. So when you get these requests for assessment, you might actually, you should be told what the worker's injuries are. You may get asked to address the impairment, like told which items in the Schedule 1 they want assessed, and you may not. If you aren't, I think with reference to what you're told the work-related injuries are, you can make a call on that. But if you're not sure, probably reach out to your instructor and ask. Sometimes it's obvious, like I think, if you've got multiple fingers that are affected, then of course, if you look at it on a common sense basis, it's actually going to affect your entire hand. Same thing, for instance, if it's an actual elbow injury and realistically you can't use your arm, then you're actually looking at the assessment with reference to below the shoulder, because it's not just the elbow's in the middle of your arm, but that really does affect, or could affect, pretty much your entire upper limb. So that decision might also not be made by you until you've actually assessed the injury, because if it's a very minor impairment, then it might just be the elbow from the elbow below. If it's a major impairment, it might be the entire upper limb. So just something to consider. And I've already touched on that. If there's competing medical opinions, we go to arbitration, which comes back to why it's really important to being clear and setting out in your report how you arrived at your opinion. So we come back to Schedule 1, the magical Schedule 1 we keep talking about. I'm just now going to show you quickly, just because it might be of interest, how these figures in column 3 are actually applied. So if you remember back to the example, we figured out that there was a 12% loss at or below the knee. That doesn't show you the lower extremities there, but it shows you that we're looking at column 3. So this percentage is relevant to the person calculating what that dollar figure is that the worker is entitled to. So we've got loss of the leg at below the knee is 70% under Schedule 1. So 70% is one of these things, and I probably should have put the lower extremity in there, and I didn't. But that's where that 70% comes from. It's column 3. And we had the 12% impairment in the example. So we calculated as follows. It's $100,000 CPI indexed times 70% times 12%. So at the moment, $100,000 CPI indexed is about $164,000. The WorkSafe ACT haven't updated their indexation guides online, so that figure's actually a little bit out of date, and it's probably higher than $164,000 now. But $164,000 times 70%, because that's what the Schedule 1 says, and then the impairment is 12%. Therefore, the worker is entitled to almost $14,000 in a lump sum compensation. So that completes my presentation. I hope that's been really helpful and given you some insight into the ACT scheme. I'm happy to take questions either now or later. I'm not sure.
Lauren, I just would like to ask a question that I'm frequently asked, and it's around the wording, essentially. So when medico-legal experts are directed to AMA 5 and then to the New South Wales Workers' Comp guidelines, they would put it in a certain terminology, but frequently the letter of instructions ask them to describe the impairment according to Schedule 1. So for example, the wording loss of sight of both eyes, or, loss of use and function below the leg, for example. Could you just provide some clarity when a medico-legal expert's asked to express the impairment according to Schedule 1, exactly what the expectation is?
Sure. So just to clarify the question, Sue, is it the case that the instructor hasn't told you which part of Schedule 1? Is that a matter? Is that what the question is, that the doctor's then left to determine what part of Schedule 1 it is?
No, I think it's just more the wording, that do I pick up this wording here, loss of right arm at or above the elbow, and is that how I describe it? And I think, from my understanding, it is as simple as that. But often that question, medico-legal experts say, what's required here? Is it as simple as just picking up that terminology under the ACT Workers' Comp scheme?
Yes, I think the answer to your question is yes. I think always best if you can, because it provides clarity in terms of then performing the calculation, of adopting the exact wording that comes from whichever item it is, or items it is, in Schedule 1. So if it is loss of right arm at or below the elbow, then use that terminology. How that then translates into using the AMA guides, I guess that's a matter for the doctor to assess, depending on the injury, because it could be a hand injury, a wrist injury, a finger injury. But I suspect that if you have that information, if you know what the actual injury is, let's say it's a wrist injury, the guide will tell you which assessment to perform, and then you perform the calculation for loss of right arm at or above the elbow in terms of providing the percentage of the impairment.
Great.
Does that answer the question?
Yes, thank you, it does. I'm just going to bring up a few questions that have come in the Q&A, and I would just direct the audience. There's been some answers put in from the Comcare section by Ben, so if you haven't seen those there, feel free to go and have a look in the Q&A for Ben's responses to things like, exactly what is the Section 57. Now we have a question for you, Lauren, and that is that if there is no permanent impairment lump sum payment for psych injuries, what does the claimant get if the psychiatric injury caused long-term permanent work capacity?
So in the ACT scheme, there's two things. First of all, if they've got long-term incapacity, they're entitled to benefits up to the mandated retirement age. So at the moment it's 67, and it will go up, I believe, over the next few years to maybe 60. I'm not sure where it's going, but I think it's going to go up. It's currently 67 or 65. Maybe it's going up to 67. Sorry for the confusion. We usually just use 67 as a standard retirement age, because people are working longer these days. So they're entitled to continue receiving benefits up till that time. If they're totally incapacitated, they're going to get a reduced benefit depending on what their pre-injury wages were. The other option is, unlike in the Comcare space, if there is negligence on behalf of the employer or another party, or an employer and another party, that has given rise to the injury, there is the option of seeking damages. So, and Ben, you can correct me if I'm wrong, but my understanding in the ComCover space, if you elect to take workers' compensation, you are precluded from also suing the government. You might have another party you might actually be able to sue for damages, but in the ACT space, you can also sue your employer. So if you've got a significant injury and there's negligence, you can also seek damages, which would then, I guess, provide you with general damages, your full wage entitlements, those sorts of things.
That's right. For the Comcare scheme, there is a limited opportunity to forego a permanent impairment lump sum. So if you're offered a permanent impairment lump sum because you've got more than 10% whole person impairment under the guide, you can make an irrevocable election to forego that amount and sue just for that non-economic loss. It's capped at $110,000 and still requires you to establish negligence. And for those two reasons, it's very, very rarely used because the maximum compensation is significantly higher under the no-fault scheme, and they've not indexed the 110 since 1988. So it's very unattractive, even though there is a limited opportunity to do it. So it just doesn't happen.
Okay. Thank you, Ben. Lauren, another question for you, and then we've got another question for Ben after that. So Lauren, an example of hernia is not necessarily clearly defined under Schedule 1. What should a medico-legal expert do when the schedule doesn't exactly describe the condition that you're asked to assess for impairment?
Well, look, that's a really good question. I'm just having a look. Hernia is an interesting one, and I am no expert on hernias, so I'm happy for the doctor who asked that question to chime in. But I'm wondering whether it's not in there specifically because it doesn't provide a permanent impairment, or typically doesn't. But again, I'm not the expert on hernias. Perhaps someone could let me know if that's the case or not.
So the doctor who raised the question, I've now opened the microphone if you'd like to talk.
I asked the question, I'm Adam Rappaport. Sometimes hernias don't wish to be repaired,
Right.
and there's a drag on the person. They can't lift or perform in a physical task.
Mm-hmm.
And so some assessment of impairment is warranted, or they may have had hernia surgery and the result is not really satisfactory, and there's a lingering inability for them to perform their work. Look, I've had to deal with one matter, Sue will remember this, that we had trouble finding the section. There was no specific section on hernia, and we had, the closest we could find, I think from memory, was number 32. It was pelvic disorders.
Yep.
And I think from memory, it was a while back.
I'm just having a look as well. You're right.
It's
There's not really a lot of
second
areas
page
where it could fit in.
And maybe if there's another medico-legal expert out there who's contemplated the same scenario, pop your hand up and I'll give you the mic as well.
Yeah, because it seems to me, I'm looking at it, it definitely looks at both your upper and lower limbs, your bowel. It doesn't look, and apart from your sort of back and musculoskeletal system, it doesn't seem to contemplate your torso a lot. Or your groin specifically. So I guess if you've got a hernia in your groin area, you might be looking at your lower limb. Otherwise, it seems to be an anomaly and missing in the act. So that's an interesting one. Where was the hernia that you were dealing with in that example? Sorry.
Oh, well, it was in the groin, which is not really in the lower. It's at the junction of the torso and the lower limb, if you like.
Yeah.
I wouldn't have thought that it would be appropriate to put it under the lower limb.
It's not a leg like you say, because it's either leg at or above the knee or below the knee. It's not really either.
And ultimately, I was asked to see this person before surgery. I understand that he had surgery subsequently, and I assess him afterwards. But in most cases, he'd have a satisfactory result. And if you're asked to assess impairment, then there's no question that there is any impairment in most cases. But there would be occasions where a hernia is not fixed. It's a large scrotal hernia. It's interfering with work. The person doesn't want to have a hernia done, or is wearing a truss, which is not completely satisfactory, controlling the hernia. And so some sort of And I personally had difficulty on that one occasion, overcoming it. I think we eventually came up, Sue and I worked on this and brainstormed it with the referring solicitor, and I think we ultimately came up with a satisfactory answer, although I'm not exactly sure exactly how we did it, but it did provide a challenge for us.
Yeah, I can understand why.
Drew Dixon has now got the microphone, and Drew is very experienced in matters for ACT workers' comp. So Drew, I'll hand over to you.
Well, the inguinal hernia has its own section in the work cover guides of New South Wales, which is now PIC, and these are in the guidelines. Now, to assess the hernia, has there been a recurrence? Is there a palpable gap? Can the hernia be reduced? Is there any induration of the scar or the mesh that's used in the hernia? Is there any neuroma of the ilioinguinal, iliohypogastric or genitourinary nerve? And does the hernia create a limp or an altered gait? So these are ways that we can assess it. And these are set out in the guidelines of the Workers' Compensation New South Wales, which Comcare has adopted. Now, I know there may be differences in the ACT, which Lauren has alluded to. The other question I have for Ben is that if this hernia has already been compensated with a lump sum, I think you did say that once that's been compensated, that can be disregarded for further assessment purposes, but I may have misheard you.
You didn't. It's extraordinary, but true. If there are if there's an aggravation or a new hernia, then you would disregard the prior compensable impairment and assess the current impairment as on a holistic basis. That is the current state of the Comcare scheme.
Thank you.
But in most cases,
Thank you.
There'll be a pre-existing condition that's not compensable. That's the more likely scenario to arise, in which case there would be some deduction.
Thank you.
Okay, we had a question here around, was there a missing page to Schedule 1? Yes, there was. Lauren had just screen grabbed a portion of page 1. This is page 2. Oh, so sorry, let me go. This is what Lauren had screen grabbed. And this is page 2 of Schedule 1. And if you would like a copy of that, just let me know and I'll send that through to you. Phil? No, I'm assuming that's what you were referring to, missing page for Schedule 1.
Yeah, sorry. I'm actually looking at it on the authorised Act 2. There's actually 3 pages, so it just depends on which version you're looking at. But yeah, there's 53 items altogether.
Perfect. I had another question for Ben, and that is regarding psych claims and the utilisation of PERS when there's a section around activities of daily living. And the question was really around what is deemed an activity of daily living. If a person would normally go to work and they're now no longer able to function without a supervisor or direction at the workplace, is that counted as an activity of daily living, or is it purely, activities like dressing and communication, sexual relations? I know there's a table, I think it's 5.1. I know there's a table there that outlines it, but communication, I guess, taken into the workplace and cognitive impairment is an aspect that, individuals are impacted at work because of cognitive impairment as well as at home. Is there any case law that, has been upheld in specific situations that can provide our medico-legal psychs some guidance as to how they should address that question?
Thank you. Yeah, so chapter 5 of the guide, and that's the current guide and the new guide, it's probably the most straightforward table of all the tables, in my opinion. So it's not a PERS assessment, it's assessment in accordance with chapter 5. So again, read the introduction, principles of assessment, glossary, so you have that background. And when you attack chapter 5, there's a table which sets out a non-exhaustive list of activities of daily living, and then a table, it's derived from an earlier AMA, but essentially it's with reference to the performance of activities of daily living that have been defined. Although it does say, if there are other activities of daily living that are relevant, take them into account. Do they require supervision and direction in relation to the performance of those activities of daily living? Yes, no. And how many of the listed criteria do they have? For example, reactions to stresses of daily living, which cause modification to daily living patterns, etc. So the assessment itself is pretty well mapped out. So in terms of case law, there's plenty of cases that talk about the assessments, and the dispute will be a factual thing about whether or not the claimant in fact has the claimed difficulties, and that's more of an evidentiary thing, because obviously the doctor is going to be generally looking at a clinical record and having the benefit of an interview to form the assessment, and obviously people can perform differently on 2 different days of the week, and it's very common to have 2 different assessments of the same person under the same table.
Okay, thank you for that. All right, I think we now have looked at all of our questions that have come through, so thank you everybody for your engagement in this and asking lots of questions. As mentioned, if there's any other questions that come to mind as you're closing off for the day, just shoot me through an email, suelarson@meddirect.com.au, and I'll pass those through to our experts, Lauren and Ben. So thank you all for giving up your evening tonight. Really appreciate your attendance and your questions, which has been really helpful. But I'd also like to say a very particular word of thanks to Ben and Lauren for sharing their knowledge and first-hand experience with us all. I think it's fair to say it's helped us enormously to better understand the schemes and to be equipped to deliver high quality opinions that meet the unique legislative requirements of each of the schemes. So thank you very much for sharing your expertise with us, Lauren and Ben. We very much appreciate it. So good night, everyone. I hope to see you next time, and have a good evening.